Okay, have we taken a position yet on the bill?
We have not met
Okay,
since that language came out.
okay. All right.
Very good. Thank you, Senator Mendoza. Have there been other schemes, related to this issues, other corporate schemes or other uses within the DCA that have allowed corporations to kind of maneuver around and practice without some licensing or without any oversight? Have you noticed any before? Or seen any?
I know that in the case of optometry, there was an issue when lens crafters came in, and I don't know the details, but I know that there were some enforcement issues there. I think that as a layman, all of us can understand what happened in the pharmacy industry when large corporations like CVS came in. They came in and basically bought out all the smaller mom and pops. And so now all of the pharmacies, while there may be a few small ones left, they're almost universally large. Now, I can't speak to the enforcement issues that have presented for those boards, but I know it's impacting our board to the extent that the corporations that are coming in are asserting that we have no ability to to hold them accountable for the laws that are in place.
And the court reporters that are performing the services through these corporations, or these outside or foreign corporations, are those court reporters all in California?
Yes.
They are.
And they are licensed in the state of California.
That makes it kind of a little challenge then to go. I can understand their, the corporation saying, well, we're just the facilitator or the middle person. But I can see the challenges, and hopefully Senator Mendoza's legislation will help in that regard.
If I may, Senator Hill, that's the reason that the board promulgated regulations on the scope of practice, because it is the common misunderstanding that simply writing on the steno machine is all that court reporting is. And so we promulgated the regulations that actually define the scope of practice. And there's so much more to it. It's setting up calendaring. There are requirements in the Code of Civil Procedure for review for a deposition, for example. There are rights that a deponent has, and there are many things that are out of the control in a situation where the reporter reported the proceeding, but everything else is handled through the firm. And so it's clear that court reporting services are being offered.
Very interesting. How much, getting back a little bit to the issue that we were discussing before over the transcript reimbursement fund, how much of the $240,000 allocated to the pro bono account each fiscal year is used? How much of those dollars are used today?
On the pro bono, I'm sorry, on the pro per
this would be on the pro bono fund.
On the pro bono, that varies every year.
Average about?
We haven't maxed it out in probably 10 years.
Is it minimal? I mean,
it goes from 160 to probably 240 in the last, I would say, over the last.
That they've used, okay. So that wouldn't be, there is a need for that fund then still for the pro bono?
There definitely is a need.
That's good, thank you. And then on the pro rata issue, it's, there seems, when you look at 11-12, it was 137,000, 12-13 was 81,000, and then back in 13-14 to 142,000. Do you know why it dropped and then came back so high?
I do. The benefit to working with Department of Consumer Affairs is when a board gets into a financial straits position, so to speak, if you're not able to afford your fair pro rata, then they basically let you continue using the services and during the lean years. But when you're fully funded again, then they will try to recoup some of that. So it's, yeah, they want their money back.
Okay. That's good, thank you. And then the other question, and you raised it a little bit about examination fees and testing, barring changing the statute to allow for to increase the cap. Have you looked at almost at every opportunity, or have you thought of a number of opportunities to raise funds without doing that? Because the reality in this building is getting to a 2/3 vote to do that is very slim, and that's why I believe you're having a hard time finding an author to carry that bill. So have you looked at have you exhausted every chance to see, whether it's examination fees or some other type or vehicle that could be used to increase revenue?
Speaking to the revenue, I'm sorry.
No,
Thank you. Speaking to the revenue, our main source is the license fee, obviously. Looking at the examination fees, it's relatively low. We have a 3-part test, and so it's only $25 per portion, $75 total. That's relatively low for what we're doing. Even if we doubled that, we only have about 500 candidates a year taking the test. So while we may net another 20,000, it's nowhere near enough to, say, fund the transcript reimbursement fund on its own or anything like that. The board's been very diligent about cutting costs. I mean, we've been on a very lean budget for a number of years in anticipation of hitting this spot. I think that we've done a good job in postponing the inevitable moment as long as we can.
If I could add too, we're also restrained just by our legislative mandate, correct?
Yes.
If I'm wrong. We're not a for-profit group that can go out and use other measures to raise funds. We're very limited. It's just through license and examination fees. And so, as it's already been pointed out, that's finite.
Very good, thank you. Other questions? Yes, Senator Bates.
I believe I heard you say that in terms of the indigent client, that the means test is actually determined by the attorneys. Did I hear that correctly? And is there any formal procedure to determine that we all are, or you all are aware of, and to ensure that they are doing their due diligence with their clients?
That's on the main fund, the larger portion of that. And the attorneys, when they submit the application, have to sign something attesting to the fact that this person truly is indigent, that they have gone through it. And I don't know if it's under penalty of perjury, but as an officer of the court, they're not going to sign something that's not true. Where the board does find out things as we're looking at invoices and going back and doing our end of the processing, it's not uncommon for a court clerk to say, what do you mean this person's trying to get money? They show up to court every day in their Mercedes or what have you. I mean, it gets back to us.
Right. I raise that question because once upon a time, participating on an assessment appeal situation, somebody with multi-million-dollar properties think they're indigent. So I think there should be probably a little more formalization of how you determine, or how an attorney does, something that puts some parameters around it, because you could declare that and perhaps an attorney doesn't even know until they actually see their balance sheet or whatever they're showing in terms of, and especially in divorce cases where there's a lot of emotion there. So it's just, to me, it's maybe a little too loose in terms of the trust of just a declaration when we're looking at things that are focusing on raising fees. We're happy to raise fees. I'm one of those who voted for that in the past, but I like the evidence to show, why, and really evidence-based fee, because fee for service, not a problem for my side of the aisle. But when it's very vague, and a lot that I've heard today, it's kind of vague, that makes it very difficult. If we really have a situation, and I think what you're talking about in terms of justice for those who really need help financially to get that, very important. So I think there should be some formalization or a little more confidence on our side that there really is a vetting process.
Point well taken. And I would also point out for the committee's edification, when a case is won by somebody who has used the transcript reimbursement fund, they will pay the money back. So the fund actually does get quite a bit of money back on the pro bono side. Oftentimes those are large cases, not in the nature of class action. And so when they do win, we will, it's not uncommon to get several $1,000s back at a time from the cases that have been successful, the funds that we've done. So that does help keep the fund going even longer.
And if I may add, I believe the board is happy to put in a formal way of dealing with this. It's just low budget, not much time. We meet 2 or 3 times a year. We would like to aggressively go after putting something formal in. So maybe in the coming time, we can increase our meeting time and address that issue, because we too have talked about it.
Great, thank you.
Yeah.
Thank you, Senator Bates. Other questions or comments? Yes, Assemblymember Mullen.
Just a quick one to our co-chairs. Thank you very much for the opportunity. Davina, wonderful to see you. Davina is a city councilwoman in my district and is doing an incredible job. So you've got multiple hats here. So my question is on the workforce shortage. I serve on the California Workforce Investment Board, so whenever I see the word workforce, my antenna goes up. So the shortage of court reporters and transcription services being provided, is that unique to California, or is that, I mean, is that a national phenomenon, particularly acute in California because of our structure, or what are some of the dynamics there? Just a curiosity.
Would you like to, or you want me to?
Well, it is a national issue. The average court reporter right now is age 56 in the United States. And at the same time, the schools have been very proactive, as well as the different trade associations, in letting the world know that this is a viable and wonderful profession. So the schools are starting to become stronger with more reporters. And I don't know, Yvonne, if you want to speak to California in particular.
California is a large problem simply because we have a large judicial system. So by virtue of the fact that we have a huge market for court reporters, LA County, for instance, has more court reporters than many states have in their entirety. So I think it's a function of that. It's not more unique than that. It's just the size of the system that you're dealing with.
Interesting. Very good, thank you. This is an opportunity for anyone in the public who would like to comment on the Court Reporters Board, Board. Excuse me. Good. Mr. Howard.
Madam Chair, Mr. Chairman, members, Ed Howard of Howard Advocacy, representing the Deposition Reporters Association. I'm pleased to have with me today Moneen Black, incoming and new DRA president, Ms. Black, and Ms. Toni Pallone, our longtime legislative chair. With your permission, Madam Chair and Chairman, I want to address quickly the question related to Senator Mendoza's SB 270 and answer your question, Senator, because they're related. And then, again, with your permission, I'll turn it over to Ms. Black to talk a little bit about the big picture when it comes to enforcement. Before I begin, the staff, this is a really well-done Sunset Review report by staff. And I do want to compliment staff. It was a difficult report to write. I'm a fan of good writing, and it was terrifically written. Relating to SB 270, the DRA is in support of the bill as it currently is in print. As it currently is in print, it does not embrace firm registration. The author's office has, and we support the concept of firm registration, although recognize two things. The first is that many different states have it, and it has yet to prove very effective in deterring corporate wrongdoing. And that's related to the other problem with firm registration as an effective tool all by itself, and that is, to the extent that the corporations will claim that they don't provide court reporting services, they simply won't register. And then you have the same situation as you do now when you're going to have to go to court and prove that they're professional corporations to force them to register. It simply potentially moves the problem to a different place. Nevertheless, it is helpful, at least not hurtful, and we do support the concept. The problem comes when, in an effort to ameliorate and address the opposition to 270, there may be a proposal that in exchange for firm registration, which, as I just mentioned, really moves the problem to a different spot, one would propose to allow the foreign corporations in, make that what is currently unlawful lawful, and likewise repeal the current law, which is longstanding, and which is seen in one way or another in virtually every one of the DCA licensed professions. And that current law is that corporations, in order to ensure their accountability, have to be owned by licensees. So while we would support a bill, any bill, including SB 270, that would simply embrace firm registration, we would, with respect, vigorously oppose any bill that in exchange for firm registration repeals either of those two current protections in law. And that's directly related to your question, Senator, because as far as we're aware, we are aware of no precedent anywhere within the land of Department of Consumer Affairs that allows corporate practice without some licensee on the hook somewhere. In the majority of professions, and of course, both chairs are very familiar with the LensCrafters. Yes, I'm sorry, you have battered elected official syndrome with it probably. But in all of the Department of Consumer Affairs professions, either you have a provision that requires the corporation to entirely be owned by licensees, i.e. 100% of the shares, or at least in two contexts, you do see movement that allows more flexibility. For example, in pharmacists, a pharmacy can be a corporation like CVS, but there must be a, quote, pharmacist in charge, that's actually a term in the code, that must be a licensee that has direct supervisorial and management control over the other licensees. Again, a license is still on the hook somewhere. And likewise, in the contracting state licensing board, there has to be a, quote, responsible manager or officer employee. Again, corporate practice is permitted, but an individual license still has to be on the hook. And that's the way to ensure at least a crudely level playing field. Because Ms. Pallone and Ms. Black are both firm owners and licensees. They have a personal skin in the game, meaning they could lose their license if they, as a matter of a corporation, misbehave. And unless there is a corresponding personal skin in the game when it comes to corporate practice, and the playing field isn't level. After all, the whole reason we invent corporations is to prevent individual liability, to shield individuals from liability. So that's our position relating to firm registration, SB 270, both as it's in print as it perhaps might be amended. And with that, respectfully, I'll turn it over to Ms. Black and Ms. Pallone, and thank you very much for your time, unless you have questions for me.
Thank you, Mr. Howard.
Madam Chair, Mr. Chairman, members. My name is Monine Black. I'm the president of Deposition Reporters Association of California. DRA is the only California trade association and the largest in the nation that is run solely by and devoted to court reporters who are not employed by courts, but who freelance. Whether we are individual reporters or firm owners, like Tony and myself, what distinguishes us from our official colleagues is that we are small business people working in a competitive market. And what's happening in my profession is unfair, unprecedented in any of the licensed professions, hurtful to consumers, and unlawful, and it needs to stop. In most professions, including mine, this legislature passed laws saying that corporations had to be owned by licensees, had to obey the same laws as licensees, but notwithstanding these laws, out-of-state corporations not owned by licensees for years and years have been stealing customers away from California companies by doing this that would get my license revoked if I did this. Offering kickbacks, offering to help one side in litigation, offering cut rates on the original to those who hire them and make it up on the back end to the overcharging on the copies when the lawyers have to pay those costs. Nothing like this rampant, unlicensed, unregulated practice has ever happened in any licensed profession before, and it has to stop. We, the freelancers at DRA, are unafraid to compete on the basis of quality and price, but we should not have to compete against businesses that are here unlawfully and that act unlawfully. In conclusion, and with respect, it is not enough, as staff recommends, that the board simply monitor a bill to address this problem. The board, a board comprised of earnest, dedicated, intelligent, and caring members and staff, is charged with enforcing the laws passed by this legislature. If for some reason it can't be done, it needs to It needs to tell us exactly what it needs to do its job. I can tell you this, until someone inside a corporation has a license at stake the same way that I do, and they break the law the same way contractors do and pharmacists do, the playing field will remain unfair. Thank you for your time.
Thank you.
If I may, Madam Chair, Mr. Chair, I'd just like to add a little bit to what has already been addressed by Ms. Black and also was touched upon by Ms. Cram and Ms. Fenner during their presentations, and that is the distinction perhaps between the services provided by a court reporting firm and those court reporters that do the work for them. Every agency operating in California has to go through like functions. The foreign corporations, unlicensed corporations that are working here now provide court reporters just as I do in my agency, just as Ms. Black does in hers. There are certain functions that are taken over by that agency that are actually requirements of the certified shorthand reporter by the Code of Civil Procedure that are done on a daily basis. As an explanation, a reporter is assigned to a deposition by a firm. The reporter reports that deposition and transcribes the proceedings. At that point, the transcript is turned over to the agency that they've done the work for, and that agency is in control of the transcript from that point forward. They control the pricing, they control the invoicing, they control the production, they control the delivery. All of those places in the handling of the transcript could be done with unequal delivery, unfairness, and bias in terms of pricing, timely delivery, services rendered and offered. Those, because they are so involved in the handling of the transcript, the production of the generation of the work, and the production that follows, and the pricing that comes with that, and the ancillary services, it's absolutely critical that our Court Reporters Board have the authority to discipline them, have the authority to insist that all of these corporations are performing the same services and following the same laws that are impinged on certified shorthand reporters. And I think for that reason, given the proliferation of foreign corporations working in our state now, that is a great concern to us. It's more than ever important that the Court Reporters Board be continued so they can take whatever action is necessary to solve this problem and cure it so that the consumers of California legal services are protected from any wrongdoing and any unfairness that we see going on now.
Thank you.
There are a couple of quick items in the Sunset Report that I wanted, technical items that I wanted quickly to address. Yep. The first is that DRA joins with the board in requesting a fee increase. So let's be clear, this is the people who would pay it, asking you to please make them pay more. The second is the Sunset Report does a really terrific job, and I think the board does a terrific job in explaining the requested changes and reforms to the way that the TRF is financed, including the flexibility to be able to move money between the two buckets of pro per and pro bono. We very much support that. We very much support the ability of the Court Reporters Board, perhaps in consultation with the Judicial Council, to identify vexatious litigants to make sure that the TRF is not abused, but in fact exists, as in Senator Bates mentioned, for people who truly need it. And it certainly makes sense to try and align the fiscal years between the two buckets. That's just a happenstance of how they were enacted. And then finally, I would be remiss if I did not thank very much Assemblymember Bonilla for her work on 270, her staff's work, and I regret that Senator Mendoza left. We at DRA are deeply appreciative of him and his staff for working toward an equitable solution. We hope to be able to find something that everyone can agree with. Thank you.
Very good. Thank you very much, Mr. Howard. Very good. Other members of the public? Good afternoon, gentlemen.
Mr. Chair, Ms. Bonilla, Mr. Hill, thank you very much for this hearing today. My name is Michael Harold. I'm a lobbyist for the Western Center on Law and Poverty. We are one of the support centers that actually can access the transcript reimbursement fund pro bono portion, and we also represent the legal service communities of California. This is a very important aspect of the Court Reporter Board's function. The management and the continuing work they do around the transcript reimbursement fund. I can just tell you by the number of phone calls I've gotten in the last week from a number of directors of legal service programs how important it is for them that this fund and this operation continue forward. So we have had a chance to review the proposals that are in the staff's recommendations in the proposals and from the board, and we are open to some of the proposals around potentially being able to move excess funds from the pro bono portion of the fund to the pro pers fund. I mean, when the pro per fund was created a few years ago, we took a very close look at this. We wanted to ensure that there would not be that this program wouldn't end up eating the pro bono side of the fund. The caps were put in place for a reason, but we recognize that many people do have to represent themselves in court, and they do need transcripts, and we do think it would be potentially useful in those years in which the pro bono side doesn't fully use its allocation, that we are able to move some of those funds over. We are also open potentially to an increase in the fees. We hear Senator Bates and her comments, and I think there's probably things that we could work together on to make that happen and move that fee portion forward if we all agreed on that. But I do just want to stress that it's very important that we continue the transcript reimbursement fund. It allows us to protect our indigent clients, the folks that we work on, and a host of public benefit programs and other areas of the law, and we encourage the committee to pass that. Thank you.
Thank you, Mr. Harold. Mr. Guerrero.
Good afternoon, Madam Chair, Mr. Co-Chair, I should say. Ignacio Hernandez on behalf of the California Court Reporters Association. I want to thank both co-chairs and the committee consultants for all of their work on this report and also for putting together this review. I think it was a great job, and really the bottom line is we want to state our support for the board. We think the board is doing great work. They are oftentimes in very difficult position in trying to address consumer issues and all of the varying competing interests of consumers. And they are very diligent and a very steady hand is what I would say, very aggressive and steady hand, but also they are very careful not just to be persuaded by emotion or hyperbole or intimidation. They do their job and they do it well, whether some of the licensees like it or not. And we respect that, and we agree with the board, and we think the board should continue in its regulatory capacity. I think they're doing great work. Let me just add a couple of things. As a statewide association, we represent, freelancers, official reporters, firm owners, cart captioners, as well as other hearing reporters in a variety of capacities. We are also the sponsor of Senate Bill 270, which was raised earlier. I did not anticipate such a thorough discussion of our bill. Do appreciate it and look forward to a fuller discussion in front of Chairwoman Bonilla later on in the year. But I do want to comment very quickly on that. I wasn't anticipating to make any comments about our bill, but I would like to say a couple of things. One is we appreciate that the Court Reporter Board did take official position in support of the bill in its current form, and we know that they're taking up the proposed amendments that we have come April, as was indicated earlier. There's also probably some clarification that needs to be made over the proposed amendments based on earlier testimony. There seems to be some confusion about what the proposed amendments would be. I can tell you this. We have members who have come to us as licensees who have rightfully received word from the Court Reporter Board about potential impropriety when it comes to some of the practices that were described. And these are reporters who are licensees who, went to go work as a reporter in depositions arranged by some of these entities that have been mentioned today. And the board rightfully began to investigate improprieties, what appeared to be improprieties and potentially violations of law and violations of some of the rules. And it's a tough position for the licensee to be in, because we heard a lot about, oh, we have to be tough on licensees. Well, that's true. When the licensee is merely showing up and doing his or her job to the fullest, and the foreign corporations, the foreign entities, simply make the arrangements, and they like to dance around the jurisdiction of the Court Reporter Board to do anything, then we feel it is absolutely incumbent upon us to go after them. It is unfair to the licensees who are actually sitting there, and what a lot of folks would say, providing the services, to be under the jurisdiction of the board, and yet these other entities to be able to dance around, thumbing their nose at the board and saying, well, come after us if you can. Our bill in its current form provides significant authority and stiffer penalties and authority to go after them. And the proposed amendments, which we will, which will be heard later on in the year, will add on to that, not replace, but add on to that requirement that that these entities make clear that they must comply in making these arrangements for reporting services, must comply with state law and state rules. It's very similar to the law in the state of Texas, which ironically is the home state of one of the main entities, which we've been having problems with in California. So look forward to getting some clarification from both Co-Chair Bonilla and also Co-Chair Hill as we go forward. But we think it is a win-win as we think the bill is going to go forward, and it will help everyone. And so, again, we didn't anticipate a debate on our bill, and there were certainly some misstatements about what our bill is going to do, but that's okay. That's not the point. The point is we are here today in supporting the board, supporting its efforts, and thank them for the diligence in which they do their job, and rightfully, crack down on licensees if there are problems, and rightfully keep an eye on the industry and the workforce, not just as it is now, but we know they're doing diligent work and looking forward and how to address the needed growth in the workforce in the coming years. And we look forward to continued communication and collaboration with the board. I want to thank them for the work, and we do support the board continuing in its capacity.